Hello, friends. Good afternoon. In today's editorial, our special topic is regarding the sedition laws. You can see there that today we will try to understand uh, about these sedition laws in India. We all know that today this law is being taught everywhere. We know that how the people are being implicated by the government under this law. So it has given a space to the people to talk about the sedition laws in India, whether the laws which has become archaic by now, should we retain those laws or not? If we retain such laws, then how it can affect your freedom of speech, free speech? We also know that recently the petition have been filed before the Honorable Supreme Court of India, and Supreme Court has put some very fiery questions to the government about the retention of such laws, those laws which during the British time were used against our national father Mahatma Gandhi ji and Tilak, against both these the people personalities. The sedition laws were used by the Britishers. Now let us try to understand in a very simple way that what sedition is. हमें बिल्कुल सिंपल वे से पहले ये अंडरस्टैंड करने की कोशिश करनी है कि आखिरकार सेडिशन जो है होती क्या है. I would say that sedition, it is a conduct. It may be by way of so many other things. For example, by speech, by signs, by visible representations. It is a conduct which incites the people to rebel against the government which is established by law. कहने का ये मतलब है कि ये कंडक्ट जो किसी भी तरीके से जो है वो फॉर्म किया जा सकता है. आप वर्ड से कर सकते हो, स्पीच से कर सकते हो, रिप्रेजेंटेशन से कर सकते हो, किसी साइन से कर सकते हो. और वो जो कंडक्ट है आपका इन एनी ऑफ दीज फॉर्म्स, अगर वो लोगों के मन में एक रेबलियस जो है वो फॉर्म करता है, उत्पन्न करता है कि हमें गवर्नमेंट के खिलाफ जो कि लॉ द्वारा एस्टेब्लिश की गई है उसको हमने उसके खिलाफ जाना है, रेबल करना है, तो उस कंडक्ट को हम इस कैटेगरी में लेके आते हैं, सेडिशन की कैटेगरी में. So I want to tell you that the amplitude of this law is very, very wide. In our Indian Penal Code, there is a section 124A of the Indian Penal Code, which specifically deals with the sedition. I tell you that this law was, the necessity of this law was felt long back when Britishers came into this subcontinent to rule. They were under the fear because since the Britishers have suppressed the Wahhabi movements, therefore they were under the fear. They were scared lest the Muslim preachers in Indian subcontinent may wage war against them, feeling this necessity, implicating by this necessity, the Britishers brought the laws of sedition in Indian Penal Code. The difference, I would also like to tell you that the difference between the law which brought Britishers in Indian Penal Code was, and the law which is at present is that during the British time, Britishers, this law was not made cognizable offense. Cognizable offense होता है जिसमें पुलिस without the authority of the magistrate can arrest the person on their own. During the British time, when they introduced this section in Penal Code, the sedition law, it was not made cognizable offense. It was made cognizable offense during the regime of Mrs. Indira Gandhi in 1973, making the cognizable offense non-cognizable, converting the offense from non-cognizable to cognizable. The repercussion of such amendment is that it has given more lethal teeth to the law in 1973, whereby the police on its own could can arrest the person against whom this law is used. So more teeth were brought in this law in 1973 by making it a cognizable offense during the time of Mrs. Indira Gandhi. So you remember this also, the basic difference during the British time and uh, during the present time. So this is the precise history which I am telling you, that how this law came into being. Now, the adverse effect of such laws can be felt on your right to exercise your free speech, which is guaranteed to every citizen under Article 19. So, the adverse effect of this sedition law, which now have become archaic, is on your free speech. You can't uh, uh, speak freely about the government policies, about anything done by the administration, the government. If you dare to speak, then you might scare that if I speak, say something about the government policies, if I criticize the government policies, if I comment upon the government policies, then there is a scare in your mind that you might be arrested by the executive, you might be arrested by the government. So, this is how your free speech is intersected, impeded. When you start feeling scared, saying something, commenting something about the government, about the administration, then it tantamounts to curtail, curtail the free speech of the citizens. This care is the test. This is the yardstick to measure your free speech. This is where the sedition law badly affects your free speech. This this needs to be understood. This needs to be understood that the test of your free speech is when you don't have fear in your mind, scare in your mind to say something about the government policies or commenting on the government policies. If those policies measures are not in your favor, you can comment on those policies on measures to correct those things, to bring them uh, on the corrective measure. So this is the test. When you scare, it means uh, you are not exercising your free speech. Your constitutional right is curtailed somewhere, and this is badly affected by the use of sedition laws. Because if law is used against one, two, three, or four, the others will start scaring. The I tell you, the courts, the role of the courts comes later. Before that, executive, the government can cause you a lot of harm, damage, because of the use of this instrument of sedition law. If we go by the by the section 124A, it has a wide amplitude. The executive, the authorities can trap you in any of the element, the ingredient which this section speaks about. This needs to be understood. The amplitude. And once you are trapped under sedition law, then you will be arrested, you will be taken into custody, and thereafter, the role of the courts may start, will start rather. But by that time, the damage, the harm is done to you, and nobody knows how long you have to suffer behind the bars. You can see around. There are news on TV channels, in newspapers, that how the law is being used, and uh, innocent people are put behind the bars, and there is no trial yet. And they are uh, just rolling behind the bars. So the role of the court starts later. Before that, a lot of harm can be done by the authorities. I just would like to read out for you the sedition law, and how wide its amplitude is to trap someone. 124A sedition. This section is in chapter 6 of the Indian Penal Code, and it reads out like this: whoever by words, either spoken or written, or by signs, or by visible representation, or otherwise, brings or attempts to bring into hatred or contempt, or excites or attempts to excite disaffection towards the government established by law in India shall be punished with imprisonment, which may extend to 3 years, to which fine may be added, or with fine. This is the main section of sedition law in India, in our Indian Penal Code, 124A. You just see the wording of this section. It has left nothing. According to me, there is no loophole. The authorities can trap you in any of the expression quoted in this, incorporated in this provision. It may be, say, for example, suppose if you bring hatred, or even attempt to bring hatred, or contempt, or disaffection, means disloyalty towards the government which is established by law, then this section can be imposed. For example, if you say something about the government which may not be seditious, but the authorities made it seditious because they the government has the infrastructure, the huge legal department, which may word the things in such a manner that it it falls within the category of this sedition law. If you say something that can be formed into that, and you may be trapped, if the authorities want you to trap, then they will trap you. The amplitude of this section is such a wide. You can't escape if authorities are behind you. If they have solicitous that they want to trap you, then they will trap you by using this section, by bringing your speech uh, into the parameters of this section. The role of the court will come later. What courts think about this law. But by that time, as I have explained you, that by that time you will be behind the bars and there will be no escape thereafter. We are witnessing day to day now how this law is being used. So the question of interpretation comes before the court, not before the executive, I tell you. You understand what I am trying to convey you. Before court will take up your matter, by that time a lot of damage have been done to you already, because the police, the authorities, they can bring you within the parameters of this law very easily. Court will decide later when the question of framing of charges will rise, uh, and it doesn't rise in a day or so. It may rise after 3 years, 4 years. That question rises later. You you focus on this law, whether there is necessity to retain such laws when nowhere in the world, nowhere in any of the civilized society, such laws are in existence. There is no such law in UK, and these are the UK people, Britishers, who brought this law in India, and in their own country there is no such law. You keep in mind that also. So you have to go by the section of this, the ingredients of this law. It is, I will reiterate that it is easy for the authorities to trap you within the parameters of this law. If you say something that will be converted into the parameters, that will be converted into the expressions of this law, courts will see later what was there and what was not there. So what I am trying to convey is that whether you need this law or not, and if you need it, why you need it. According to me, in any of the constitutional democracy, there is no necessity of such archaic laws, seditious laws, because it adversely affects your constitutional right. of free speech, which I earlier explained to you, the test of which I have explained. If you scare to say something about the government policies, that you might be trapped, booked under sedition law, then your free speech is curtailed. Then it means that right is nowhere, that constitutional right is nowhere in existence. If that right is there, then such scare should not come into your mind, because it is the constitutional right now to criticize the government policies, to say something about the government policies, whether those policies are in your favor or those policies are not in your favor. If they are not favoring you, people should have people should have the right to criticize those policies, and compel the government to correct those policies, to take corrective measures in favor of the people. This is what the democracy is. This is why we say government by the people, government for the people, government of the people. Why we say that? If people cannot criticize government policies, if they cannot say something about the government policies, about the government activities, then how can we say that this government is by the people, of the people, and for the people? So you have to understand all these things. So my focus is that sedition law is not required at all. If really we want to exercise our free speech, then this law is not required. This is ultra vires of the constitution. This law is excessive. It is archaic. It is instrument of suppression in the hands of the authorities. So we cannot favor such laws in a civilized society. We just look around and see where such laws are in existence. If this law is not in existence in UK, then what is the necessity of this law in India? Is there any necessity? No, there is no necessity. But I tell you, all governments, they have their own policies, their own political ideologies. They go by that. We never know which government could turn out to be a authoritative government. And if such government comes, then such laws are instruments of exploitation in their hands, which will directly inhibits your constitutional rights, particularly free speech. We have seen how many journalists, how many people were booked under uh, sedition laws. So, according to me, there is no necessity to retain such laws on the statute book. Such laws should be declared ultra vires and should be struck down straightway. And then you will see the difference in your society and in your free speech, which is your constitutional guaranteed right. You understand this. You must. This is why I always emphasize that every citizen must know about their constitution. At least they should know what is contained in the constitution, because it is the constitution which ultimately prevails all over us. Therefore, it is important to know about your constitution. Ignorance may lead to damage your own rights, your own existence. So I was talking to you about the section 124. Then there are two or three explanations appended to this section. Those explanations are very important to know. Uh, the explanation one is the expression disaffection includes disloyalty and all feelings of enmity. The first explanation defines what disaffection is. It says that disloyalty, sort, and feelings of enmity are within the purview of disaffection. Explanation 2, it says comments expressing disapprobation of the measures of the government with a view to obtain their alteration by lawful means without exciting or attempting to excite hatred, contempt, or disaffection do not constitute an offense under this section. I will read this third one also, then I will explain it. Comments expressing disapprobation of the administrative or other action of the government without exciting or attempting to excite hatred, contempt, or disaffection do not constitute an offense under this section. Now, the subsequent two explanations are very important. Suppose if some government takes some measures and you feel that this is not this measure is not perhaps in your favor, or uh, it doesn't suit the society, the public at large. And if you dissent, if you disapprobate, your this disapprobation with the government measures to alter it, you say कि भाई ये चेंज होनी चाहिए, ये पॉलिसी ठीक नहीं है, ये मेजर ठीक नहीं है गवर्नमेंट की, तो इसमें अगर आप अपनी असहमति, आप सहमत नहीं होते हो, तो इसका ये मतलब नहीं है कि आपने सेडिशन जो है कमिट कर दिया। लेकिन प्रॉब्लम कहाँ पे है? ऐसे ही थर्ड जो कमेंट है, एक्सप्लेनेशन है, वो भी यही कहती है। दोनों का मतलब एक जैसा ही है। उसमें सिर्फ इतना ही किया है कि एडमिनिस्ट्रेटिव और अदर एक्शन ऑफ द गवर्नमेंट जो है वो ऐड किया है। दोनों को अगर मिला के हम पढ़ें तो इंटरप्रेट करें तो इट हैज़ द सेम इंटरप्रिटेशन, मीनिंग suppose government takes some measures and you do not accept that measure, you want that it should be changed, it should be altered because it is not useful. Should we say that this is seditious? According to this explanation, this is not seditious. But who will decide this? When authority is after you, when they want to arrest you, they want to harass you at any cost, then you may say anything. And whatever you say, that will be brought within the purview, within the amplitude of section 124A, and you will be harassed, you will be arrested, you will be put behind the bars. Such interpretations are to be decided by the courts. It is the job of the courts to interpret law. It is not for the executive. Executive is to apply judicial mind, but when they are bent upon to arrest you under this law, then they will forget about this judicial mind. They will just arrest you and put behind the bars under this law of sedition. Because the government wants that. तो मैं क्या समझाने की कोशिश कर रहा हूँ, आप कोर्ट को साथ साथ रखिए। हम सोचते हैं ना कि कोर्ट जो है आपके रेस्क्यू में आएगी, कोर्ट आएगी आपके रेस्क्यू में डेफिनेटली, बट व्हेन कोर्ट विल कम टू योर rescue later, when already the damage is done to you by the executive. This is the whole crux of this debate. कि कोर्ट तो बाद में आएगी, पहले तो एग्जीक्यूटिव ने आपको डाल दिया होगा ना बार्स के पीछे, फिर कब तक रहेंगे, नोबडी नोज दैट। ये इंटरप्रिटेशन एडजुडिकेशन ये लेटर बाद में आती है, तब तक एग्जीक्यूटिव अपना काम कर गया होता है। तो हमें ये देखना है, वी हैव टू सी दिस वेदर दिस लॉ हु इज सो ferocious, should the nation retain such laws when the nation is being governed by the constitution? Free speech is guaranteed to us, then how can we retain such laws? Such laws must be declared ultra vires, who are so ferocious, who are so dangerous, injurious to your constitutional right. So this is the point which I am trying to bring forth before the public in this editorial of mine, that whether to retain such laws or not. No, fortunately, the petition is before the Supreme Court of India. We have to wait now what the Supreme Court of India does about this, what decision comes forth. By now, the court has put queries to the government of India, that why such laws should be retained, which were used against Mahatma Gandhi and Tilak. Now we have to wait. But for your understanding, for your information, it is very important that you should understand the law of sedition in India and how it can be a lethal instrument in the hands of the authorities. This is where my focus is. The courts will definitely protect you, but they will protect you later. When such law is already used by the authorities. by the government. Hopefully, the simple way which I have told you to understand this law, you might have taken some points at least for consideration. You, it, I might have made you understand in a simple way that this is the sedition law, this is the history of this sedition law, uh, how this law could become an instrument of suppression, oppression in the hands of the government, the authorities, the police. Uh, it is for you to see and to understand and to make your opinion regarding sedition law in India. With this, I will end my episode. Hopefully, I will meet you again in my next editorial. Till then, I will say goodbye. Thank you. Have a good day.